Okay, now we are back. So it's very important. If you have a chronology, you have a date, you have a day, you have a document, and then event, and then the reference of that document, it will be very good for you to look at time and again. Now, here is my another suggestion to you. When you prepare the chronology, at the end, you should add a column, extra column, and I call it, put it as a remark. Remark column is something for you to take note of that or say something. For example, when you are reading two documents, two emails, and you find there is something wrong and something is not matching, then you can write it down over there. You may also think that this was a wrong reply. You can write it down there. Anything which you find that something you want to say, something your reaction is there, write it there, the column. And then you can use it, or you can consider and reconsider it later. And many times you can find that even in the moot problem, which is drafted for many months, edited many times, and still you will find discrepancies. When I was reading, I have already found 2-3 discrepancies over there. Even the mistake of date, I have found that. And the mistake in language, I have found that. So same, it will happen. And when later on procedural order number 1 will come or 2 will come, then you will find those corrections have been made. But here, when you are reading it carefully, you will find the same thing. So this is the remark column is there. Now, here is the sample of preparing your chronology of facts. The first column, you can use Excel file or you can use table, whichever you want. Here, the first thing should be date. What happened? Date, below there, you should also write day. For example, 14th of April, 2020. If it was Monday, then write Monday. Then you see events. What happened on that day? So you can write claimant sent email to respondent, for example, or Mr. So-and-so sent email to Mrs. So-and-so. So you can write it there. So this is what basically happened. Then you should write mode of communication. Was it only email? Was it fax? Was it sent by courier or all? Write it there. Then here you should write the brief summary, that what happened on that day, the point. And this is the last column, is about remark. What do you want to say? Your reaction, your comments, you can add it over there. This way, your chronology will be very well and very structured. It can be used. Then it comes that how we make our chronology final. For that, I have a 3 steps process to suggest you. Assuming in your team you have 5 persons, then I suggest that all 5 individually read it and then prepare your own chronology. The table which I suggested you, prepare on your own. Then you circulate this table to all of your team members and let everybody see everybody's team, everybody's chronology. What will happen when you are doing on your own? You are just one person, your one pair of eyes, reading that, picking up. You will be very surprised that so many other indication of time you may have missed. When your friend or your team member will look at that, they may pick up something extra. You can pick up some mistakes in their chronology. So if 5 people will check each other's chronology, then very likely you will complete, you will pick up every date, every time, everything related to that. After this circulation, I suggest that you make one final chronology, a combined one. So if 5 people's work, you combine into one, and that will become your team's combined chronology. Trust me, if you do that, you will not miss any facts. It will be very, very surprising that you may have missed something. But even if you have missed something, no problem. Still, the moot will continue. You have 8 months time to come again and again to do that. But by doing this way, I will be very surprised that you miss anything. At least 98% of the facts, you will get it there. So that's the way we do it, a final one. This is all about the chronology. Now, the second thing I suggest, in order to understand the whole case, you should read either the same time or read one more time. And this time, only you look for the people who are involved in this case. We call it dramatis persona, or we just simply call it actors who were involved. So for example, on the very first page, you will see the lawyer of the claimant has sent the notice of arbitration. So we have a name of the lawyer. In the statement, notice of arbitration, we will see the name of the company. We will also see the name of the CEO, COO. We will see the marketing person. All these names will start coming. So you pick up all those names and make a table and say, James. You write down, who is this James? What do you know about him, about the personal thing? See that James, what is his experience? What is his role? How he is involved in the case? To what extent he is involved in the case? All those things. When we are saying age and experience, professional background, these are very important. For example, if the two lawyers are negotiating the contract, it is assumed that the lawyers, they know about the law. So whatever they are saying, they are doing, or the proposing, they understand the legal consequence of that. But if the same thing is done by somebody who has no legal background, he or she only knows about marketing, then the marketing person, if they say that I am offering you something, this is my offer, I don't think they understand that their word offer in law means something else. So their idea of proposal or their act, their conduct may not be treated or interpreted in the same way, the way we interpret lawyers' conduct. When you are looking at age and experience, you can find out, and if this year, if you can see in the witness statement, you will find the name of the person and you will find date of birth. So date of birth will tell you how experience or the age of the person. This fact is also very important. When you make an argument, you can see that a person who is involved in the business for many, many years and a person who has just joined, just started, their understanding and ideas will be totally different. And these can be used in our argument to show that how their conduct, their words and expression should be interpreted. So all these information, whatever you want to find out, write it down. This will help you to understand that the person involved in the case, like a witness, how the witness sees the case, what the witness has understood about the case, understood about the facts. So you will see whole case from the eyes of that actor. This will give you another dimension, another perspective of understanding the facts in the moot. I also suggest that you take note of, prepare that for arbitrators. They are also actors in this case, counsels, lawyers who are involved in that. For example, This year, again, you have 3 arbitrators, but the one arbitrator who is presiding arbitrator, you will see he has done so many things because the rules require him to do that. This year, also, if you see council, there's a one council is very special, and that council has requested a very special thing from the tribunal and says that if you want to communicate with me, then you use only this mode of communication. So this is something interesting information about her. So these are the things you should prepare. So never forget the actors, the people who are involved in the case. Make a list of that and collect all the information related to that. Then when you are reading it second time, then you can also pick up all those things which are related to law. So list out all the laws which are discussed over there, whether it's related to contract like CISG, whether it's related to UNITAR principle, you write it down. Whether it's related to arbitration rules, write it down. Whether it's guidelines like guidelines on conflict of interest, ethical rules, everything which you find, you write it down. What is the purpose here? You are not doing anything, but in one file, in one paper, you write it down so that later on, when you are going to write your memo, you have to understand that these are the law you have to deal with and you have to do the research on that area. So it will help you to guide you in which area, on which law you have to do research. While you are collecting law, another suggestion I have is that you should look at your case and think about that, which industry or sector of economy it involves. This time, it is a palm oil. So now, as a student, when you go to the moot, and later on, when you want to argue the case, it is always a good idea to understand how palm oil industry works, how they export and import, what are the common terms they use in the palm oil sector. Knowing the business sector is very important and it will help you. So note down that, and I think this is very obvious. In this obvious situation, only one industry is involved, so it's easy, but you have to understand this and you can note it down, no problem. Sometimes you may have more than one industry involved. So we can see here, this year, they say that palm oil and palm kernel has 2 different standards. This is for you to do the research, but take note of that, which you can do it at this stage. This is the purpose of that. While you are doing it, we also need to prepare table of abbreviation, because if you look at the moot problem, they have some 2 letters word, 3 letters word is abbreviated. It has a different meaning. Even if you don't know, no problem, but take down those abbreviations. Later on, you can research and you can find the full meaning of it so that you will understand what they are saying. For example, if it says the goods must be delivered on CIF terms. CIF terms is a very normal Incoterms you will know later on, but maybe at the start you don't know anything about it. But take a note of that. Later on you will find it. What happens when you write the memoranda? We use lots of abbreviations. Abbreviations helps us to reduce our line, our number of words, all those things, so that we will have full 35 pages for us to argue. Because in the Vis Moot, the number of pages is limited. So this helps us. But in any way, this is one observation which is there, that you must find all the abbreviations from the moot problem at this stage. Not from anywhere else, but from the moot problem. Now, when you are dealing with this, in the third reading, meaning now you have to read the moot problem for the third time. You have already prepared your chronology. Now you have to read it for the third time. In the third time, we suggest that you should do side-by-side reading. What is this side-by-side reading? We say that first, say for example, you have a notice of arbitration. It appears on the first part of the moot problem. And then after several pages, you will see the response to the notice of arbitration, because the respondent has replied to that. If you read cover to cover, then you read a statement, notice of arbitration first, and after maybe 15-20 pages, you will read respondent's response to notice of arbitration. By the time, you will forget about that, what was in the notice of arbitration. So therefore, we suggest that at this stage, you take the notice of arbitration on one side and take the response to notice of arbitration on another side and read paragraph by paragraph. And when you do paragraph by paragraph, you will see the agreement or disagreement between the parties. So you can highlight those things. You can highlight those things and see what happens, like, what are the disagreement, what are the agreement, you can find it. You can do the same thing with the claimant's witnesses, and you can do with the respondent witnesses. In the moot problem, you have a witness statement. Just put those two witness statements against each other and see to what extent they are following, what extent they are not following. So this is what you can do. At this time, when you are reading it, I will also suggest you to read all the correspondence which arbitration institution has sent to the parties. Most of the time, students ignore this part. I would suggest it will be a mistake if you do that, because when the institution or the presiding arbitrator, they write it, any communication to the parties, there is some important information there, which you can use it later. And it might help you. I can tell you, in my experience, at one time when we were arguing our case, my team was arguing in Vienna, there was a very important information which was there in those correspondence. Many people or many teams did not notice that. And we noticed that. And we use those facts. So the lessons to learn, and I can also tell you that I have also seen the teams who were sitting on the stage, but the question was asked from the arbitral tribunal perspective, that what the institution has done, and the team could not answer. So I suggest that you should also read those pages and see what is this conversation is about and what is the information is there, you collect it. So when I say side by side, it is like this. Notice of arbitration, you can have a response to notice of arbitration, read paragraph 1, compare with the paragraph 2, and you can make it this list and you can highlight the similarity, differences, everything. Same you do with all the exhibits, do all with the witness statement. So in that way, you will see immediately that what is the position of parties on such and such thing. So it will be easy for you to find out. Okay. Now, after reading that and carefully looking at all those things, you should also prepare a list of agreed facts. In the moot problem, parties may disagree with each other on the facts, but there are certain facts on which they agree. So all those things, you need to do it together. So first time, when you are doing side-by-side reading, it will give you some ideas where parties are agreeing and where parties are disagreeing. But if you want to find out more about where parties have agreed, there are certain places where you have to read it carefully to find out that. Which is, if you see presiding arbitrators letter to the parties, particularly this year, in this one, he has said clearly what parties have agreed. If you look at procedural order number 1 over there, you will see it is said clearly what parties have agreed. This is very important. agreed facts will help you in the writing as well as the oral presentation. For example, this year, the parties have agreed that they will use 2021 rules, although in the contract it said something else. A good student, a good team prepare these facts carefully, and it is very important. In the argument stage, you can just say that respondent has already agreed to this fact, and you can say, Mr. Arbitrator, you can see page 35, paragraph 2, there they have stated this. It means they have agreed with us. That will be a very good use of facts, and this one will be seen by the judges very well, and you will get extra marks for that. So the agreed facts in the moot is a very important part to do it. Now, I say that the fourth time you should read the moot problem. When you are reading the fourth time, the idea is that this time you focus and collect all those facts which are related to the issues given in your moot problem. For example, this year there's a dispute on jurisdiction. If it is there, then assuming you can write here the issue on jurisdiction of the tribunal. Here, on behalf of claimant, you can write down what are the facts you have which supports that the tribunal has jurisdiction. And at the same time, while you are reading it, you can also take note of that on behalf of respondent, what are the facts you can use to prove that the tribunal has no jurisdiction. At this stage, when you do these things, everything will be very easy for you. Both sides' argument you will understand, both sides' facts you will understand, and when you start drafting your memo, you can just look at these facts and you can write your memo based on the facts. And when you are preparing these documents, all the facts which you are getting it, please use page number and paragraph number. This will be helpful. Just writing the facts and you do not write the page number, then it will be difficult for you to find. So that's the way you can prepare it. Trust me, if you do it for issue 1, issue 2, issue 3, issue 4, and you look at the documents every time, then although you are doing a fourth reading, actually within that you are also reading several times. Every time when you read, you understand some more, you remember some more, and your clarity will increase quite a lot. So that's why you have to work in that direction. Here, you may not have seen this one in your moot problem, but in 2 weeks' time, you will receive the procedural order number 2. Procedural order number 2 is issued in a question and answer format. And you can see this year in procedural order number 1, it is written that if teams have any question related to contract, related to agreement, related to anything, they can ask the question. There's a category. So what happens? The organizers, they collect all the questions and put it together as a general question or a kind of a specialized question, and then they answer. When you receive that, I suggest that you read each question, and before you read answer, think about it, that why somebody has asked this question. What is the purpose behind that? How this question is related to facts, how these questions are related to your law, how it will be affecting your position, how it will affect the other side's position. Try to understand that. If you understand the question, the purpose and the meaning behind it, then it will help you a lot in clarifying the facts. Then you read the answer. When you are reading the answer, after reading, pause it, think about it, that here the answer which has been given is a fact. How you can use those facts in your case? Has it changed your earlier position? Has it changed the position of respondent? Think about the answer, because generally the answer is, the first part of the answer is in one way and the second part of the answer is in another way. And that's how the moot is balanced. But you need to understand each part of it to understand how it is happens. In the answers, if you see numbers, like I say, the number of quantity, quality, or industry related or profit related, all those figures are there. Generally, the lawyers are not very good at calculation. So these numbers, most of the lawyers, they ignore it. But you should think about it. If the answer is given in numbers, there must be some reason. It can be used, and it should be used, and it must be used. A good team and a good student can take help, can think about it, and try to understand how I can use these facts in my argument. This is what you have to do every time for every question. Think about it, how I can use this information in my favor. If you think, then all these questions which will be asked will help you, and it will do that. Having said that, if you are looking at procedural order number 2, you need to go back to your chronology, your agreed facts, your table of facts as per the issues, because so much information will come in procedural order number 2 that you have to revise it. Revise all these tables. But once it is done, then your facts are done. You have completed most of the part, and now you are ready to start the second phase of the moot. Therefore, when you are doing it, I just want to give some tips related to the moot problem. My suggestion is that when you print the moot problem, and I suggest you should have a hard copy, not just computer, because your eyes cannot pick up so many things on the computer, but the hard copy is very good. When you print it on one side. Don't print double side. And the reason I ask you is because one side is printed, other side is not, then you have a one blank page where you can write your comments, your observation, your reference, anything which you want, you can write it over there. So always keep something for yourself. The second thing I will suggest that when you print all these 45 pages, don't staple it. When you staple it, you have to flip the pages like this, and it becomes little inconvenient. I would suggest that use punch hole, and so that you can flip completely, and then the blank page, you can utilize it properly, and everything will be in a proper order in that case. We have tried this skill that after preparing the chronology, when the team has sat down, they looked at each other's chronology and prepare one single one. Then after that, we sit down together and we play the game, pass the parcel kind of a thing. So if the team members are sitting, say I am the first one, so I will start the story from the beginning, that what happened in this case at the start. So I will start, or say for example, I say in 2020, the two parties meet for the first time in the trade fair. Then my next team member will say, what happened after that? And then the third person will say, what happened after that? So in that way, everybody will recount the story in the sequence. If they do that, then whole team will learn and know what happened and their logic and their sequence. Because this sequencing is very important. If you do not do that clearly, if you do not have a clear idea about it, then you will be having some problem in that case. So this game is very important to clarify in every team member, that everybody understand the facts, understand what happened, when it happened, and in which sequence it happened. If you remember like that, then if any question is asked in in the oral presentation, and somebody asks that whether this event happened after this or before this, then if you remember, you can easily answer that. Even if you miss that, no problem. You have a chronology, you can go back, look at, and you can answer. But this one is a good exercise, good fun exercise at the first time. Then we also try to remember that, say for example, in the moot, if we have a James, so we say James, and I ask you, tell me, who is James? What is his age? What does he do? When he involved in the case? Which extent or to which level he was involved? Then we go to the second person. We say, who is this person? When it joined? On which side he joined? What is his role? All those things we do. In that way, we try to understand that which actor has done what. So if you have prepared the list of actors and their activity, then it will be very easy for you. So you can play this game also. The third thing which I like it is we play the random quiz among the teams. So say for example, we ask when the contract was made, when this email was sent, and from memory, team try to say, oh, on such and such date, on such and such date. We ask when the terms of condition were changed, so they should remember it. This is what it happens. So this a small fun activity will make a student very happy. They will not feel pressure, and together when they work, together when they ask question and tease each other, then they become very good friends. They become open to each other, and they work like a team later on. So all these exercises build you to prepare a formidable team who can do much better in the case, in the moot problem. Another suggestion, which I really suggest, that from now onward, every week after preparing all those things, every week you should read the moot problem cover to cover. And you will be very surprised that every time when you read, you will pick up something extra. You will pick up something different. And that is very important. I also say, when I was coaching, I told my team is that whenever you make a mistake on facts, it is non-excusable. We cannot pardon that. And your punishment is, if you mistake on the facts, you do not remember the facts, then the punishment we give you is that you go and read the moot problem once again, cover to cover. You can do that self on your own. You promise to yourself that whenever I will miss the facts, I will go and read the moot problem one cover to cover again. And in this way, it will help you to understand the facts more and more and more. Trust me, if the facts you control and you know it better, then in the moot, in the oral presentation, you will be miles ahead than your competitor. And that's why we start with this one. So I say, good reading of moot problem, preparing a good chronology, having a good and correct understanding of events, reading the moot problem, picking up the minute things, inferences, reading between the lines, all those things together, it will make you a good team, a good student, and it will develop a good skills under you to find out that what are the material facts which you should see. Later on, when you become the lawyer, it will be very helpful to you. You know how to handle the paper. You know how to handle evidence. You know what to pick, what to leave. You know where to focus, what to not to focus on this one. But for the moot purpose particularly, if you master the facts, half of the moot is already done. When you start writing, you will remember the facts, and quickly you will remember, oh, this fact, from this page, from this paragraph, you will start writing it. After writing the memo for claimant and respondent, when you go to the oral argument, facts will be in your mind. If questions are asked, even if you forget the law, even if you forget the case, at least you will remember the facts. And you, on that basis alone, you can answer your question. If the facts are in your favor, you already have a good, strong case. And therefore, we suggest that this should be the good start. And that's how you should do the mastery. So at this stage, I stop here and thank you very much for your time and attention. You can ask the question if you have any, and I will answer that without any problem. All those things which I suggest you, it is our own self-learning from our own mistakes for 25 years, which I am sharing you so that you should not do the same mistake. you should not commit the same mistake, so that you head a start and even further. So thank you very much.
Thank you so much, sir, for that very elaborative presentation and all the knowledge that you shared. As sir said, we are now open for questions. If there are any, please write them in the chat box and I will read them out to sir. We are open to questions now.
And we can also inform them that this is recorded and it will be uploaded on our website, Asia-Pacific VIS Moot.
Yes, sir, of course. So we have a question in the chat box. Mr. Harsh Sharma writes, how important are the numeric values in the problem?
It is important. We have to see what the context you are talking about. Numeric value, yes. And that's what I was saying, that in procedural order number 2, you get more of these figures. And it is important. The factors are important, like what is the value of the contract? If the value is so big, then the people will be very, parties should be careful about it. If the quantity is very large, then we have to think about it. In this moot problem, we also have said that you can deliver it in installments, and it's up to 5 installments. So you need to remember, it's not just 5 equal installments, but up to 5 installments. It could be 3, it could be less. So all these numerical values are important. And I tell you, this is the problem, because most of the lawyers are not very familiar with these calculations. So they may feel little difficult. Last year, there was a table with lots of numbers given as an annex in procedural order number 2. And very complex arguments were built, and the easy arguments also built on that basis. So yes, it is important. Everything in the moot problem is important.
Thank you, sir. So we have 2 more questions right now. One is from Mr. Ahmed. Mr. Ahmed writes, one second, sir.
Yes.
Mr. Ahmed writes, what are your suggestions, guidance for beginners in moot court competition?
This webinar is the first thing which we have suggested you. How to read the moot problem, what are the things you should pick it, that's how you should start. But even before that, if you have decided to do the moot, this is the beginning, because you need that courage, you need that fire, you need that passion to come forward and take this challenge. If you have decided to do moot, I should congratulate you now, because you have already started. Once you have started, the first thing is that to understand what you have to argue. And for that, you have to understand and learn how to read the moot problem, how to use these facts. And that is specifically the reason that we are giving this first webinar. After all those things which you handle, I told you the way you should prepare the chronology, the days, dates, list of actors, side-by-side reading. Then the next stage is to do the research, because you need to do some legal research and other. For research also, we understand, and therefore we are organizing another webinar on how to do research. And then you have to write it. So we also have a plan to give a webinar on how to write your memo. So these are the things you have to do it. And then later on, you have to make a presentation before the tribunal. So we will also give you the oral presentation skills. If you do all those things, you don't need anything extra. All those things are there. But most important thing, your own commitment, your own passion, and your own determination that I want to do it and I will do it. Okay.
Right, sir. Thank you. We have a question from Advocate Dr. V. Sundaresan. The first question is, do we have a specific period for the power of attorney to execute contracts of a minor, even after the minor becomes a major in Indian law?
Sir, I can only say that this question is very specific. It's not related to the moot problem and it's related to Indian law, and I should not be answering that here in that case. And I think your second question is also related to that. So for that, we can have a separate discussion, and I cannot claim here to be answering that legal question on this public forum. So sorry about that, but we can discuss this separately if you want.
Right, sir. Thank you. So we have a follow-up question from Mr. Ahmed. And Mr. Ahmed says that if I'm interested in argument as a counsel, but my team members want me to be a research person only and not a speaker, then in such case, what should I opt?
I can tell you the one thing is that the Vis Moot or any moot problem is a teamwork. You know, the success of team is not only about one individual. It's like a construction of the building. When you are constructing a building, every brick, every mortar, everything has to be aligned in a proper way. If anything misses out, then it will be very bad. So I can tell you from my own experience of 25 years coaching so many team members, big or small, even the research person is a very integral part of it. We call them that they are the spine of the moot team. And I can tell you that when my team succeeded in Vienna, we had we assigned one researcher for one oral presenter. That researcher, the job is so important that at that time you 100% rely on that person. So when we are preparing and going against any team, and we suddenly find that the other team in making an argument or using a case which we didn't know about it, then this researcher, we rely quite a lot. And these researchers are so skillful that they immediately Google, find information and brief and prepare everything and come back and tell us in 3 lines, in 2 minutes, that what is this whole thing. Meaning the researcher has to find the material quickly, read material quickly, make a good summary, and come back and tell us in clear word that, okay, this is what happened. Assuming we are totally relying on this person, and if this person is not doing the job, not doing well, then the oral presenter will not have the enough material to argue, and then they will miss out. So we say that whether you are a writing person, whether you are a research person, whether you are an oratory person, every person, in general, everybody has certain skills. A good team, a good person should have all the skills. That's the bottom line. But many times we have some people are very good at research. Some people are very good at writing. So in the team, we look at the strength of everyone. And together, if you collect the strength of everyone, you should be there. So my suggestion is that only speaking is not important. Research is good. And if your research is good, then slowly you will try it out. And I'm sure you will end up being a good speaker. In my experience, I had several opportunities where I thought that this student may not like to speak. But over the period in 8 months, he or she did so much research that they know better than anybody else. And then after that, it's just speaking so easy. Then it makes it so easy for that. So take your role, whatever role is assigned, play accordingly. Be a team person. Together you will learn. Individually, you can't do anything. Okay, so that's my suggestion.
Thank you so much, sir. So the next question is from Mr. Abdul Malik. Mr. Abdul Malik writes, thank you very much, very informative. What would be your general advice for addressing the applicable law issues in the case this year? Example, what law applies to the general standards of sale, arbitration clause, and the contract?
It's a very specific question you are asking me, but I can just tell you that if you look at the procedural order number 1, it gives you enough indication about that, which are the laws applicable. In general, you can think about it. Law applicable in contract may or may not be the same law applicable on the arbitration clause. So these things are different. And if you do a simple research, actually these issues are not being asked first time. In the past also, these issues were there in the moot problem. So if you just have a quick research, then you will find out. And actually, we took down those questions, and we were thinking about that when we will do the next webinar on research, those issues we will tell you. And if you want to understand, just take a basic book on arbitration or basic book on contract and just look at the section on applicable law. Even the big book you have and you cannot find it, go back to the table of index and look at applicable law. It will give you the page number. Go to that page number and just read it. You will understand. So far as applicable law on arbitration clause is concerned, some articles are there, easily available on Google, written articles, and you also have some cases, very celebrated cases from India also. You can find it. There are hardly 4 or 5 cases are there. You read it, you will know it. Okay.
Right, sir. Thank you so much, sir. I think you've answered everyone's queries and we do not have any more questions left. So if there are no further questions, with your permission, I would now like to conclude the session.
Please.
Okay.
Thank you.
Sir, it was an honor for us to have you present with us today. Thank you so much for taking out the time from your busy schedule for us. I would also like to thank Mr. Gaurav Verma, our interpreter for the day, to come and create such a comfortable environment for our participants today. Lastly, I would like to thank our participants. I understand that it is a weekend, and thank you so much for joining us today to learn the knowledge that our resource person had to share with us. I hope everybody across this forum keeps safe. Have a good evening, everybody. With that, I shall now be ending the meeting.
Thank you.
Thank you so much, sir.
Thank you. And all the participants, wait for our next webinar, which is coming pretty soon, and it will be focused on the research. And here we are all together, learning together, and we are sharing with everything with everyone. So in your team also, please encourage or any schoolmates, classmates who have any kind of disability or any kind of difficulties, please encourage them to join. Even if they are not going to compete in Vienna or Hong Kong, give them opportunity to come here and try out our moot. If you need assistance in helping them or doing anything for them, let us know, and we will make sure that we will provide everything to you. Thank you very much. Thank you. It is a pleasure. Bye-bye.